Welcome to Talk of the Bay. I'm your host for today, Meilin Obinata, and my co-host is Reggie Meisler. We're going to talk about public records and why they are exciting from Atlanta to Santa Cruz. So one of the things that might catch your attention is the fact that after the George Floyd protests since 2020, there are about 70 cop cities that are popping up around the United States, like Fitchburg, which is a suburb of Madison, Wisconsin. There's a project which will cost $50 million. San Pablo in California, $43 million. Hershey, Pennsylvania, $300 million. And, of course, maybe the most famous, Atlanta's Cop City. You might know about it. I'm going to read you something from Teen Vogue from May of this year. They described it saying, the construction of Atlanta's Cop City, a $90 million facility slated to take up more than 85 acres of the Meilin forest, has caused local and national outrage. If the project is completed, it will be one of the largest police training facilities in the country. Plans include military-style training facilities, designated explosive areas, and shooting ranges. The plans also feature a mock city, complete with greenery, and a replica of an Atlanta city block where police can run drills and practice, quote, urban warfare. Now, the developer of this project is the Atlanta Police Foundation. That is a nonprofit carrying out the work of the city of Atlanta's police department, and things like the construction budget and other things related to that development. Those are things that the Atlanta Press Collective and the Lucy Parsons Lab have requested under the Georgia Open Records Act. Well, the Atlanta Police Foundation did not or has not responded, which is why they have sued the Atlanta Police Foundation to get those documents. And that is one of the reasons Joy Ramsingh is representing those plaintiffs. Joy Ramsingh, her practice focuses on transparent government issues and appellate litigation. She has significant experience with the private and public sector, counseling news media organizations, business entities, and individuals. Prior to establishing this practice, she worked in a private firm in Philadelphia, exclusively handling transparency and media issues. Before that, she was an appeals officer at the Pennsylvania Office of Open Records, where she also served as an appellate and amicus curiae counsel. In that role, she also issued hundreds of binding legal opinions in public records appeals. So just to recap, she is the attorney now representing the Atlanta Press Collective and the Lucy Parsons Lab in their search for public records from the Atlanta Police Foundation. Joy, do you read me?
Yes, I'm here. Thank you for having me.
Thanks for being here. I'm just wondering, like, before you became a lawyer, how did you see public records? Did this sound like an exciting area of law?
Not at all.
Okay.
Not at all.
Okay.
And in fact, it didn't. It wasn't until I really dove into the work that I realized how exciting and attractive this was as a field. And I think there are a lot of attorneys out there who have no idea the myriad number of ways that public records can really influence virtually every area of law.
Every area of law? What do you mean by that?
Well, I mean, to the extent that you are bringing a case or defending a case that in any way touches a government entity, right? Mm-hmm. The acquisition, understanding how to obtain public records, understanding what to ask for and where you should go to ask for it is critical. I have seen civil rights cases that have been transformed, through body camera footage. And the same thing goes for, humble car wreck cases. Mm-hmm. it's really even, real estate cases can benefit from pooling code violations and things. So, now these are not really the types of work that I do. My practice focuses primarily on sort of pro-democracy, the pro-democracy types of cases. But the work is certainly fascinating to me, just from the legal standpoint.
Okay, and when you were an appeals officer, did you learn a lot about sort of like the misunderstandings people had about the law regarding public records?
I did. And one thing that I think is also interesting is that since I left Pennsylvania, so Pennsylvania has a very robust public records law. And it's received a lot of attention. There's a lot of litigation, and a lot of the judges there are very familiar with public records disputes and how to handle them. In other states, that's not the case. And what's really been interesting to me since I left Pennsylvania, and I've done some, work in Georgia now, and I still probably 50 to 75% of my practice is still in Pennsylvania, but I also do this work in other states. Pro hoc vice, meaning I go in on a one-time or case-by-case basis to different states. It's been really fascinating to be in states where there are less robust laws and to be able to educate the courts and other litigants about how the laws work.
And then how do the courts or how do the judges react when you are educating them? Do they take well to that?
So, of course it depends, right? It's always dependent upon the judge, but I find that generally it's well received. And what I love, one of the things that I love about public records work is that it is truly nonpartisan. I mean, there are very strong liberal arguments for why public records should be immediately available. There are very strong conservative arguments for why we need a good, clean, accountable government. So I do find that it's, helpful to point out to the court that this rising tide lifts all boats, and that making public records accessible to everyone benefits everyone equally. Truly, it does.
Thank you for that. Now, could you let us know how you became the lawyer for this case? Because it sounds a little bit like a hot potato.
Yeah, I think that's a fair characterization. This case was originally initiated by the University of Georgia's First Amendment Legal Clinic. And then at some point, I received a call from the clinic simply asking me if I would take the case because they had a conflict with the case. To be quite honest, I have, asked for clarification. I haven't received clarification on what that conflict is. As I understand it, I believe that the conflict is with the fact that, as a state institution, they're basically part of the government system to some extent. So they viewed that as a conflict. And at any rate, I was delighted to take the case over because I believe very much in the merits of this case. I think it is an extraordinarily strong case and a very necessary one. So I was disappointed. I think a lot of open government advocates in Georgia were disappointed by the legal clinic's decision to withdraw from this case, but I was thrilled to be able to assume the mantle and be able to take this forward because it is certainly such important work to be doing.
Thank you. And just kind of broadly, because I'm going to ask you a little bit more specific questions later, but why are your clients suing the Atlanta Police Foundation? Isn't the foundation a nonprofit? I mean, why would it have public records? And why are those records important?
Right. Well, so Georgia, since 2017 and really prior to that, the way this works, right, is that very oftentimes governments partner with private entities to carry out their objectives, right? We refer to these as public-private partnerships. And so under Georgia's definition of public record, it includes records that are prepared, maintained, created by a private entity that is performing a service for or on behalf of an agency. In this case, the agency is the city of Atlanta. We're very clear, obviously, that the city of Atlanta is a public agency. We could get records directly from Atlanta. However, in this particular case, the city of Atlanta, through an ordinance that was enacted and through the contract that they have built with the Police Foundation, they have delegated to the Police Foundation this task, this gargantuan task of building this training center. But that it doesn't really stop there. We just filed a motion on Friday to bring this to a final hearing on the merits. And in that motion, we lay out some of the things that the foundation does for the city of Atlanta that go far beyond the building of the training center. For example, in addition to just building the center, this foundation houses Atlanta's police officers. They provide housing arrangements for officers in the city so that they can live within the city limits affordably within the city of Atlanta. They have bought $100,000 life insurance policies for each officer in the event that they are killed in the line of duty. They have provided them with tuition reimbursements to go to school in exchange for their agreeing to stay on the police force for an extended number of years. I mean, this foundation, by their own statements, was really created by the mayor as sort of a vehicle, sort of a private vehicle for fundraising and crowdfunding all of these policing efforts. And so in our view, these records, and really in the view of precedent in Georgia, these records are public records. They relate to these public services that are being performed on behalf of Atlantans. And you know, they also just really involve decisions and decision making that ultimately will have an enormous impact on the quality of the policing in Atlanta and on how that policing gets carried out.
Thank you, Joy. I'm going to throw it to my co-host, Reggie.
Hey, Joy. Thanks for being here. I was wondering, what are the consequences to record holders who do not relinquish public records that they're requested to relinquish?
So in Georgia, you know, there are several remedies. I mean, obviously, what we're sort of setting our sights on here is really getting the records. So asking the court to order the release of the records is paramount. In addition to that, the court can also order the foundation to reimburse us with our attorney's fees and cost. And in some instances, the court can provide civil penalties for negligent omissions and basically negligent violations of the act. The court can also provide civil penalties. I think what's most likely to happen in this particular situation is that, and certainly from my client's viewpoint, their goal is to just gain access to the records and to really clarify going forward that APF does have to comply with the law.
So I've kind of done several public records requests myself in doing local activism, and I have had some success, mostly in sort of exposing sort of either a politician or a public figure's communications on a given topic that they wouldn't otherwise like to have be public. The thing that I have trouble with often is around police records. I find that the police use lots of exemptions. They delay record release for very long periods of time, especially around body cam footage where they can ask for months or even, you know, it seems like a year plus in order to sort of do their scrubbing of the video for blurring out faces and things like that. Do you have any sort of experience with those kinds of troubles? Do you think that there are some limitations to public records?
Well, do I have any experience with those kinds of troubles? The answer is yes, because typically my clients typically my clients come to me, right, when they have reached the point, they've already filed their own request. They've already followed up as best they can. And they've sort of reached the breaking point of, okay, they're not going to give these to me. Do I have the right to appeal this to a court? So if I'm getting brought in, it's usually at the point where the exemption has not already been raised, but has been just sort of, they've doubled down on that position. So that's where I come into play. And as far as, the policing types of exemptions, different states approach this in different ways. Almost every state has, the criminal investigative exemption. Some states handle that differently. For some states, it's until the investigation is closed. For others, it's there might be some kind of sunset provision that says, okay, so many years after the case is cold, you can have the record. Some states just say no, it's just an absolute bar. But what I typically find is that it's very easy to assert these exemptions in, an email response. Defending them in court from the viewpoint of the police agency gets much more difficult. Because when for example, I've had folks insist that it's being used as part of an investigation. And then, later, as we've delved into that in court and said, okay, well, which records are we really talking about here? And what investigation? Are you actually investigating this? Is a different entity investigating this? Are you able to assert the privilege on that other entity's behalf? From the perspective of the police, everything they do is an investigation. And from the perspective of a legal exemption, if that were the case, then no police records would ever be public, and certainly that was never the intention of the legislature.
Right.
So when the rubber hits the road in the courtroom is where we can really start to push back on those issues. But you're right, that it's very simple to say, well, we're the police and we're investigating it, and that's all you need to know.
Thanks for answering that.
And we're back with Joy Ramsingh, and we were just talking about limitations of public records tools. Any thoughts, Reggie?
I guess my other question is related to oftentimes from a sort of political campaign perspective, there's demands to release body cam footage right away after an incident. And we had an incident like that here in Santa Cruz where several police officers kind of jumped a black cyclist. And part of the problem with public records, however, is that, they'll say, we'll get you that footage like 3 months from now. And that kind of puts a little bit of a hamper on political campaigns. Is there a way to speed up that process in any way that you've found?
Yeah, so, typically in my cases, time is of the essence. I represent a lot of media, and, the ability to report on something as it's unfolding is clearly very important, and it's important for the public to be able to view the footage as quickly as possible, be able to see the records as quickly as possible. What I typically try to do is whatever tool that the legislature has given me in the public records law to be able to speed up the trial process to get to a hearing as quickly as possible, I utilize those tools. In Georgia, for example, in this case with the Atlanta Police Foundation, I filed a complaint, they filed an answer, and then because I needed just some bare bones information, I filed some interrogatories just requesting basically the names of the people who had information. So in other words, just the information that I needed to know who the witnesses were going to be. And then at that point, I just filed this last Friday a motion to show cause why defendants should not be ordered to comply with the request. And in doing that, I short-circuited, which is totally permissible and encouraged by the Open Records Act. I short-circuited the entire discovery process. Because frankly, in most cases and in most states, the requester's motive for seeking access to the records is irrelevant. And what that means for me from a litigation perspective is that there's no information that my client could possibly have that the agency would need to see. In other words, there's no need for them to serve discovery on my client, because obviously the question of whether or not they comply with the law is a question that only they can answer, and they have the burden of proof. So I just filed a motion asking the court to set this for a full and final hearing on the merits as quickly as possible. And so we'll have to see how the court approaches that. In Pennsylvania, the pathway is a little bit more prescribed. There's a very clear appeal process, with the idea being to get to an appeal within 30 days or so of denial, and to be able to get a final determination or a final outcome within 30 days. But even in states where there isn't some kind of third-party agency like the Pennsylvania Office of Open Records, there are ways in which, in a fairly rapid amount of time, certainly shorter than the average lawsuit, you can push things forward to make sure that the legislature's intent, which in most cases is to give the public access to records in a quick and speedy way, to make sure that their right to know and their right to view the records is not being impeded. You can ask the court specifically, for emergency hearings, for emergency relief, to push things forward and to get to the merits as quickly as possible. And I do try to do that as quickly as possible, because the other piece here that, one thing we haven't spoken about yet is that typically requesters, whether they are media or whether they are citizens, really don't have the funding and resources available to be able to fund, a lengthy, protracted lawsuit against a government agency that lasts for years or months. That's just simply out of reach for most individuals and even media companies. So, I try to do as quickly as possible to get to the merits, so that, my client can get the records as quickly and as inexpensively as possible. And I think also it does the agency a great service, right? Because if they do, in the event that they do have a valid and justifiable and legal reason for withholding the records, that allows them to assert that sooner rather than later. And so I think everyone benefits from that approach.
Thank you, Joy. It sounds like making sure you know all the tools at one's disposal and then using them, and also calling you. So be sure to call Joy Ramsingh Legal if you have such a case. I wanted to pan out a little bit big picture. I think I read somewhere, Georgia case law has previously recognized nonprofit hospitals as possessing public records. And not that you have to be our professor or so on, but I am curious to know, how easy or difficult is it for judges in those cases to determine what were or were not public records? And are there factors that stood out to you in terms of their ability to figure that out?
Yeah, well, it's interesting, because the court in its decision in Georgia said that there's actually not a particular set of factors that are dispositive. In other words, it's not like there's a checklist that you go down and say, okay, they have fulfilled this prong and they fulfilled this and okay, yes, these are public records. It's not nearly that, bright line or well-defined. But this is what I think. And this is what I tell the court. First of all, I tell the court what it's not. Okay, I tell the court what the standard is not. And so what the standard is not is the standard that we see in a lot of constitutional and civil rights cases for what is and is not state action. So, like, for example, just recently at the Supreme Court, there was a case involving a public official's social media page. And the Supreme Court basically said that you have to actually have state authority to run the page, and then you have to be acting under that or purporting to act under that state authority before your social media page becomes, some kind of public forum. That is not the standard here. So, for example, applying that to this case, it is not required that we show that the foundation said, we have the city's authority, to do all of these actions because, for example, we're seeking like their board meeting minutes where the city isn't present and where they talk about things that benefit the city or services that they perform on behalf of the city, but the city may not be directly authorizing them to carry out those services. We don't have to show that sort of direct control for the records to be public. What the legislature, I think in Georgia and I hope in most states are primarily focused on is looking at the type of services that are being performed, right? When you are undertaking, for example, like the foundation does, trainings that every police recruit must attend. So you're directly influencing the quality and the nature of the policing of all of these people. That is a public service, period. And if it's a public service, then as members of the public, we have the right to know about that. And so the court has been instructed by the Georgia Supreme Court not to split hairs over whether the mayor knew about this particular type of action that was happening or who was in control over it or the logistics or the legalities. Clearly, for them to be able to perform all of these services on behalf of the city, there has to be some kind of tacit relationship there between the foundation and the city. Because, for example, if I were to just open a nonprofit and say, you know what, I want to benefit my city, so I'm going to have a training for all the police officers, and they're all required to attend. Even if I didn't have a contract with the city, it would be very clear that I'm working in collaboration with the city, that there's some tacit agreement between my organization and the city. So it's not so much focused on the form as it is on the substance of what is actually happening and how it affects the common good, how it affects the public. And so, it's really in the name of the organization. This is not just a 501c3 that, gathers some funds for community benefit and they send some here. This is the Atlanta Police Foundation. It is essentially a booster club for the police department. And its records are public, at least under this Smith standard. Its records are public. And, one of the biggest issues, they've actually given us some records, and they're still insisting that some, particularly, the board meeting minutes and the agendas are private. But we, for example, their chief operating officer went on a podcast and told the podcast host that it's really the mayor and the police chief and the mayor's office that sit down at the table with the foundation and have critical conversations around public safety. Okay, well, if you're making decisions about public safety, the records relating to those decisions are public records. So, I try to urge the court that the legislature can't possibly write language that would capture all of the appropriate situations. But if the legislature's intention is for public records relating to public services to be public, then that's the standard we need to go by, rather than some particular set, logistical step that has to be made before you can draw that line of connection between the private agency and the public agency.
Thank you, Joy. I just want to read from the complaint, if you would all indulge me. In light of APF's founding as the sole authorized nonprofit to raise money, conduct research, and collaborate with the city on public safety initiatives, and APF's contractual agreement to lease land from the city to build, maintain, and lease back to the city the above described training center. APF performs functions and services on behalf of the city and for the city's benefit, rendering APF's records related to the training center subject to the Open Records Act under the OCGA. And I just wanted to also identify the kinds of records the plaintiffs are seeking. Matt Scott of plaintiff ACPC submitted an open records request to APF for the Atlanta Public Safety Training Center current line item construction budget. That doesn't sound like a scary thing to be asking for. I would think as any taxpayer would want to know, like, okay, I know you're going to come to me for the money, so how much is it? And let's see, the plaintiff Lucy Parsons' lab also submitted an open records request to APF seeking the current Atlanta Public Safety Training Center line item construction budget and things like a copy of all contracts, MIUs, licenses, data agreements, and other agreement documents with the Atlanta Police Department pertaining to the development and construction of the Atlanta Public Safety Training Center. And there's other stuff in the complaint, but just reading through it, they seem very much like common sense requests. And anyone who has ever paid taxes and wanted to know, hey, where did my money go? I think people would want to know, what are the plans? What are the budgets? What are the agreements? These are conversations that, if they're involving public dollars, you definitely would want to know about. We're back with Talk of the Bay. Meilin here with Reggie, and on the line we have Santa Cruz City Cop Watch. And earlier we were speaking with Joy Ramsingh, and we'll come back to her as well. Ray, are you with us?
Hi, y'all. Yeah, good evening. It's good to be here with everyone. Can y'all hear me on my end?
Yes. Yeah. So, you want to introduce yourself? I know that you are one of the people in Santa Cruz Cop Watch. Do you want to describe the purpose? Yeah.
Absolutely, yeah. So Santa Cruz Cop Watch is a coalition that was founded in January this year as a coalition to counter police terror and surveillance that was occurring in the aftermath of the 2020 Wildcat strike that occurred on campus at UCSC. As for myself, I am a recent...
And I think the strike that Ray was referring to is... Oh, are you back? Hello?
Hello?
Yeah, it cut out for a second. You were saying that your involvement started sometime after the Wildcat strikes?
That's correct. The creation of the page was as a result of the mass surveillance that was happening at the university as a result of the strike and of the Wildcat. That is the reason why we had to create a counter surveillance tool like Santa Cruz Cop Watch.
All right. And just for listeners, I believe the Wildcat strikes you're talking about are the ones at UC Santa Cruz with the UAW. And that was, I believe, the grad student workers, if I recall correctly. Does that sound right?
That's correct.
Yeah, so the topic of today's show is the excitement over public records. So I'm just wondering, you were explaining kind of the purpose of Santa Cruz Cop Watch, but what inspired you specifically? Why were you curious about public records?
No, absolutely. So I think when it comes to public safety and matters of public safety, that residents, taxpayers, students, all kinds of constituents have a right in terms of getting to see what it is that Santa Cruz is doing in terms of amping up surveillance, in terms of buying drones, in terms of buying more military equipment that isn't necessarily being as faithful and as transparent towards the public. So it requires members like myself and other community members to have to file for public records requests to attain information that should be deemed public record, but unfortunately is not. And in this specific situation, we've been fighting to obtain records, police records, to identify officers involved in police misconduct. This has been an issue that has been going back to litigation that has been seen in Los Angeles, with the Los Angeles Police Department refusing, and the city of Los Angeles refusing to disclose police headshot photos that were deemed public records in the courts. And so that's currently the issue that we have right now in Santa Cruz, is which we're fighting to obtain records, police headshot photos of Santa Cruz police officers and of UCSC PD.
And just to be clear, right now, the Santa Cruz Cop Watch has filed a lawsuit against the city of Santa Cruz and also UC Santa Cruz.
That is correct.
For, I think they were for denials to the public records requests, which your group has filed as of, I think, November of last year.
That is correct. So originally what happened with the city is we had sent over requests for these headshot photos in November. The city ended up denying those requests and using the exemptions of right to privacy and exemptions of essentially stating that it would put the officer's risk and safety in jeopardy because of facial recognition technology that somehow potential bad actors could access. However, there is no history or precedent of any sort of technologies being used or deployed against police officers that would undermine police officer safety. And additionally, if it was such a concern to these departments, then they wouldn't regularly publish photos on Instagram and on Twitter of their officers in plain clothes and in clear public view.
Thank you, Ray. And our guest Joy Ramsingh was mentioning earlier the importance of kind of knowing the contours of the law, because Reggie had asked about sort of the consequences of what happens when agencies do not comply with records requests and how people can accelerate the response time. And yeah, it's really important to know your rights. And I know I'm going to hand it off to Reggie. I think you had some questions for Ray.
Yeah, hey Ray. It sounds like you're following a similar sort of path to what Joy laid out, right? Like you're not getting the records you want, and so you kind of escalate to a lawsuit. And then there are like more paths to escalate after that. So that's really interesting to see. You and I have both kind of done public records requests to gather info on a potential Santa Cruz Cop City project. But I would say that you have actually gotten more, you've had more success in discovering useful information using public records on this topic. Do you have any tips for people who are trying to do public records requests for investigating this issue or other issues?
Oh, absolutely. And in fact, I would encourage all members of the public to file public records requests to seek more transparency from local government, from city councils, county supervisors, because it's such a shame that you're seeing local municipalities now try to claw back public records and have state legislatures across the nation attack public records laws to try to intimidate and prevent members of the public like myself and like Reggie and like the legal representation that we have from Georgia that are now trying to prevent from members of the public to attain these records. In terms of what I could say and recommend future members is to look at the current statutes that exist, look at current information that is already public. So in terms of what you were mentioning earlier, Reggie, of the potential cop city here in Santa Cruz, language like regional public training facility, looking for specific project numbers that could be found in project reports or could be found in city master plans. Because typically these counties and cities have 10-year master plans that have projected projects that are essentially listed down to seek or to have development in the near future. And so that's essentially how we were able to identify the potential cop city that is going to be being built on public land near and in collaboration with the University of California, Santa Cruz. We were able to obtain these records by specifically targeting email communications between elected officials and potential developers who are looking to buy this land to then prop up and build training facilities that then would be at the benefit benefit of both the police departments and fire departments in local jurisdictions.
Oh, I just wanted to read something from the Instagram account. I guess there's one post that sort of summarizes the different emails Santa Cruz Cop Watch was able to discover. And I think they're here. I'll just read out. Slide 3 features Rob, and I think that's referring to Rob Odie, the Santa Cruz fire chief, features Rob following up from a meeting with the Santa Cruz City Council Subcommittee on Public Safety to suggest that the council should move quickly on the idea before CSUMB, quote, takes advantage of the opportunity. And from what I understand, UC Santa Cruz does not have its own fire department. So the relationship with negotiating the contract between the fire department and UC Santa Cruz would seem a really essential one, especially because in the hills of Santa Cruz, we tend to catch on fire. So it's... And
so essentially what you're seeing in that email is you're seeing the city of Santa Cruz attempt to strong arm the university into allowing them to build a regional training facility near the UC campus because of the fact that UC Santa Cruz does not have its own fire department. And so that was the interesting part of that, that investigation, was seeing how the fire chief and the police chief were working in collaboration with elected officials here in the city of Santa Cruz to essentially try to strong arm the university to allow them to build on university property.
That's such a great summary of that, Ray. I wanted to know, with this lawsuit, are you filing this by yourself? Did you get any sort of help in getting it started? I know ACLU is interested in supporting, but before you started, did you trigger it, or did someone who had legal sort of expertise assist you with that?
Absolutely. This was definitely inspired by the actions of Stop LAPD Spying Coalition in Los Angeles, who really set the precedent for seeking out public records in terms of headshot photos of police personnel. And through their amazing work in Los Angeles and through the work of investigative journalists like Ben Camacho, we were able to essentially collaborate and work together to craft the appropriate language that would force the city to have to disclose these public records. And so in terms of the legal support that I obtained, it was with Gina Hong, who's an amazing attorney, who's an amazing public records attorney, who's been really supportive in this process to essentially fight for these records.
Thank you, Ray. And just reading from the post, you list public servants featured in this investigation include Santa Cruz Chief of Police Berna Escalante, Santa Cruz Fire Chief Rob Odie, Santa Cruz Vice Mayor Renee Calder, Santa Cruz Councilmember Martine Watkins, Santa Cruz Councilmember Sonia Brunner. I mean, it's who isn't on that list?
It's the who's of public safety in Santa Cruz,
okay,
for sure.
All right.
And another interesting part of that email is that you can see that the university wasn't in communication. They did not know of the project that essentially both fire and police wanted to be built on university property. It was suggested, this is such a great idea that we should present it to UCSC in hopes that they would agree. But again, if they didn't agree, then we would then pull in the card of, they don't have a fire department, so we'll suggest that we will not renew the contract with the university if they don't allow us to build near the campus.
Yeah, and I'm sure everyone within listening, in earshot of K-Squid knows about not just the CZU fires, but California has a lot of dry biomass, including the UC Santa Cruz campus. So that does seem like quite a serious relationship. And I just want to remind people about what we were talking about at the beginning of the hour, that after the George Floyd protests in 2020, there have been about 70 cop cities cropping up around the United States. Joy, I wanted to ask you, and Ray also, what are the best uses that you've seen of public records law. And I know, Ray, you were just saying make sure you kind of know all the tools at your disposal, but I'd love to hear from each of you situations in which the access to public records has made a big impact.
So, there are a lot of examples that, I could point to for national, significance. I think that, Breonna Taylor's case is one in which the body camera footage from that case really proved to be critical, not so much in, the outcome of that lawsuit, but for her family to be able to obtain some sense of closure and to be able to understand what actually happened and what actually took place, right? That's one that comes to mind. The Boston bomber was tracked down through public records, through, I believe it was Relax Group that was involved with that in providing public records to law enforcement. So there are a lot of different ways in which public records are used, but my personal favorite, examples are really more humble than that in a sense. I derive great pleasure and fulfillment from watching individual citizens get answers about the problems that are not so much of national importance, but of great personal importance to them. I have a case right now in a southern state involving a single mother and a nurse who was taking care of a boy that she determined as a nurse had suffered signs of physical abuse. And she reported this to the police, and the police came and concluded that there were no signs of abuse. Anyway, that the paramedics ended up being called, that later found out the boy had a great deal of abuse. Well, she posted about this encounter on her TikTok, got about 4 million views. And of course, there was this public outcry against the police's mishandling of this incident, allegedly. And what really is interesting about that is that in the 3 months that after she posted that video, she was arrested on 11 different charges by the police, had never had an issue before, was arrested on 11 or so different charges, all of which got dropped. And she, with my help, we've been seeking the body camera footage. And so, for her, this isn't so much about, obtaining a certain kind of financial outcome or proving some political point. These are very personal records to her where, she feels that she was essentially retaliated against for doing something good in her community. And I love cases like that really show how important and what, how important it is for individual people to be able to get closure when they have had an encounter with the government that leaves them feeling violated, that leaves them feeling unprotected, that leaves them feeling that, the promise of the government to protect and serve them has not been met. That, to me, is the highest and best use of public records laws.
Thank you, Joy. And actually, before I go to Ray, I think we have a caller to the station. Hello? Hi, you're on the air.
Yes, I believe that, public access to, quote, records it's a must. We have to have things like that. And I will give you a path that I try and follow to the best of my ability. Don't lie, don't cheat, and don't steal. And then the last thing is I met a man he graduated from West Point, and he said a measure of a person's integrity is, would you do what you do if you knew nobody was watching?
Thank you. Did you have a question for either of our guests?
question of how can people get involved with making the access to records more attainable? Because I know we come up against roadblocks, and how do we get to recognize those roadblocks, and how can we deviate to go around those roadblocks and get to what we are rightfully we have rightful access to?
Thank you. Are you okay taking your answer off the air?
Oh, sure. Yeah.
Okay. Thanks so much for calling. Joy or Ray, do you have ideas for answering that?
Yeah, bouncing off what Ray said earlier, right? I think that it's important for every citizen to just ask. And I think it's, one of the things that really helps sort of raise awareness of these laws across the board is for more people to use them. The more they are used, the more familiar they become within, to the actors in the legal system and to the state governments. I have met, agencies in very rural, remote areas who have never received a public records request, or if they have, it's only been from some kind of commercial requester who is seeking a certain type of information. I think it's great for individual citizens if, think of something that you'd like to know and send a request to any local agency. Try it out, and you might be surprised by the response you get, good or bad. But the more that the laws get used, the better I think it improves access for everyone.
Thank you, Joy.
Yeah, and definitely building off of Joy's comments now is to definitely also ensure that the state legislatures tried not to roll back on public records laws and to essentially try to limit access to members of the public who would want to seek out these public records requests. Because we're seeing time and time again that cities are trying to essentially go around the law and try to do everything in their power to withhold documents that are deemed public in the courts. So I would say to definitely put pressure on local elected officials, state legislatures, to ensure that public records laws are stayed intact and that they're not gone after. Because we're seeing time and time again, whether it's Los Angeles, whether it's Santa Cruz, whether it's Atlanta, that cities are going to do whatever they can to try to not disclose this public information. And to go also to add, I think for myself, what gives me the most joy in finding and applying for these public records is truthfully accountability for officers involved in all kinds of misconduct. So for me, it started with the case of Brandon Lopez, a gentleman who was shot and killed in Santa Ana, California, by the Anaheim Police Department. And once journalists were able to access the body cam footage and all kinds of recordings that was happening in the actual incident, is what actually activated and what motivated the community to go out and protest. It's what encouraged members of the public to actually start seeking answers to why police respond to acts of mental health crises in the ways that they do.
And we are closing it on the hour. I think Reggie had...
I had just one question for Joy. This is kind of a funny story. I was doing a public records request recently of the fire chief's text history. One of the text messages was truncated, so I asked for the untruncated version. The city clerk then CC'd the fire chief on the email thread so he could see that I was the one who was asking for it. Is that a mistake, or is that something that that is okay? So
anonymity is not a thing, or?
Yeah, so, to be honest, I would have to check California's specific law. I hate to give legal advice as to a specific situation, but I will say this, as far as, I don't know that it's so much of a problem, right, for the chief to see your name. The issue is more about the response, right? Because it shouldn't make a difference who you are, right? It shouldn't make a difference why you want the records. That should never be relevant as to why it's, and especially if you're media, as to why you're getting them. So, I understand your point. But I think that my biggest concern is not so much that he knows who you are, but what the response is going to be based on that knowledge. Because it should be the responses as would be given to anyone else asking for the same information.
Thank you, Joy. Thanks, everybody, for being on the show. Joy Ramsingh, Ray Diaz, Reggie Meisler, and I want to thank Engineering, Nyanko Nyasu, Damian. All right, well, join us again on Talk of the Bay.